So welcome everyone to another session here at the Berkeley Center for Law and Technology. We have one of our favorites back today, not only a favorite speaker, but the former head of BCLT that created an incredible center here. Now he's focusing on the academic side and focusing on the pure scholar side of it. So it's great to have him back as a speaker and an instructor and an expert. So those of you that don't recognize him, I'm shocked, by the way. Everybody should know Jim Dempsey. If you don't, let me introduce him. Jim Dempsey we were just joking before we started recording, has many titles, but the one most important for this particular discussion is Managing Director of IAPP's Cybersecurity Law Center. But the things that Jim's often too humble to say himself, an accomplished author, from books to articles, one after the other, short pieces, long pieces on cybersecurity. The way I like to put it out there is probably one of the greatest thinkers and practical thinkers on cybersecurity out there today. And that's why I always love to hear what Jim has to say. So Jim, thanks for coming back. Thanks for joining us.
Oh, come on, Wayne. Happy to do it anytime. Thanks for that very generous intro, and congratulations and respect for everything you're doing at BCLT. You've taken the organization to a new level. I really appreciate that.
Well, it's easy to build from great foundations. Well, today I wanted to talk about the new rules that have come out that got a little bit of attention, but probably not as much as they deserve, because I think the enforcement date is several years down the road. So people thought, well, I can read that next month, which that's great until you push it down too many months and you realize all of a sudden you've got an audit report coming up. So tell us about what California is doing for cybersecurity audits, why they're doing it, and where they're headed.
Yeah. So on July 24th, the California Privacy Protection Agency adopted a package of rules covering automated decision-making technology, which includes AI, but not only AI, risk assessments for processing of personal information, and the cybersecurity audit rule. This was the end of a long, quite lengthy rulemaking process by the agency. And by the way, why were they doing this? They were doing this most simply and fundamentally because they were mandated to do these rules by state law. In 2020, the voters of California approved the CPRA, the California Privacy Rights Act, which substantially amended the pre-existing California Consumer Privacy Act, strengthened it in multiple ways, created the Privacy Protection Agency, first of its kind and still the only one of its kind in the country, a single state government agency devoted specifically to privacy. And by the way, privacy has always included cybersecurity. If you collect personal information on an individual, you are required to protect the security of that data against misuse. So privacy and cybersecurity in this context go hand in hand. 2020, that law was adopted. It came into effect in 2023. The law specifically directs the California Consumer Privacy Agency to adopt regulations. Initially, the authority went to the AG, but then it was transferred to the Privacy Protection Agency, specifically directed them to adopt regulations requiring businesses, and I'll quote because the words here are important, businesses whose processing of consumers' personal information represents significant risk to consumers' privacy or safety to perform a cybersecurity audit on an annual basis. And then it goes on to say that the agency must define the scope of the audit and establish a process to ensure that the audits are thorough and independent. And it also specifies what is significant risk, the factors to be considered in determining when processing may result in a significant risk to the security of personal information shall include the size and complexity of the business and the nature and scope of processing activities. So, as directed by the voters in that referendum, the agency adopted this rule. And it was a long process. They spent a lot of time on this. Wisely or not, they married all three rules in a package: ADMT, or automated decision-making technology, risk assessment, and audit. But we're focusing today on the audit one. In fact, Wayne, your point about this didn't get that much attention. Almost all of the attention on the rulemaking was paid to the ADMT, the AI, which was the AI provision, obviously of critical concern and interest, and a major initiative of a number of states. And now California is out there along with Colorado, having these regulations specifically directed at AI. But as I say, the agency started back in February 2023. They issued an initial request for comments. They issued a pre-rulemaking draft in August of 2023. They initiated the formal notice and comment process in November of 2024. And now they went through several cycles of comments. They amended their proposal several times, and then finally, unanimously, 5-0, adopted it. The rule package as a whole, including mainly a focus on the AI one, was criticized by both sides. It was an interesting dynamic. Some privacy advocates thought it didn't go far enough. Industry thought it went too far. The governor had some concerns about it, which he expressed. The agency, which is independent, took those comments by the governor into account, modified the rule, weakened it, you could say. But I think, just speaking specifically to the cybersecurity audit provision, what they came up with is quite remarkable and is going to be very impactful. Obviously, for companies doing business in California, but collecting data on California residents. Of course, that's applies to many companies that may be headquartered or incorporated outside of California, but which are subject to California laws because they have a California presence and are collecting data on California residents.
So, Jim, let me ask you a couple things about, obviously, the compromises that have to be made in any kind of rulemaking package. What were the arguments? What were the compromises that needed to come out from the governor to make this on the cybersecurity portion palatable?
Yeah, one important thing was, I think, the initial rule talked about board level involvement and put the board in charge of overseeing the audit and required the auditor to report to the board. That was cut back. The rule had always allowed the use of internal auditors, so we're not really talking true third-party audit here. You either hire an external auditor, and there will be lots of business done there by the accounting firms and the consulting firms, or you can have an internal auditor. An earlier draft of the rule said whether the auditor is internal or external, they must report to the board of directors. That was downgraded to a member of the business's executive management team. I still think, cybersecurity remains a board level concern. I think any board would be remiss if it did not ask for or have its committee that handles cybersecurity ask for and review and ask questions about the audit. So I think these audit reports are still going to be going to the board as well as to senior management. So that's a relatively minor change. There were other minor tweaks, but at the end of the day, I think on this issue, cybersecurity audits,
Right.
most of what the agency originally proposed stayed in there.
Okay. Well, a couple of things that I noticed, they really went to extremes to, I think, define significant risk. I never thought I would see a cybersecurity rule that had a inflationary term in it. I'm like, okay, you've thought through this in terms of the business and gross revenues. Tell me where this is targeted and why, for example, why is this applied to fairly large companies and not even smaller companies?
Yeah, so this goes to the question, as you say, who is a business? What is a business whose processing of consumers' personal information presents a significant risk being the statutory term. And what the agency said was, we're going to do this on two tests. One, if you're a data broker, basically, if you make 50% or more of your annual revenue from selling consumers' personal information, you're covered, regardless of size. Basically, if it's your business to collect and sell data, or 50% or more of your revenue comes from selling personal data, you're covered. Otherwise, the rule basically targets larger companies. A business's processing of personal information presents a significant risk if the business has annual gross revenue over 26 million and it processes the personal information of 250,000 consumers or households, or it processes the sensitive personal information of 50,000 or more. Now that 26, you referenced the inflationary factor. This goes back to the coverage of some of these laws. Generally, the legislature, or else I can't remember whether it came from the referendum or not, but the law has this inflationary factor. It started at a 25 million, and every year it goes up. The last recalculation was 26 point something million. By the time this takes effect, it'll probably be up in the neighborhood of 27 million. But 27 million in gross annual revenue, that's a lot of companies. And then you go to it's thousands, potentially tens of thousands of companies, private and public. We're not only talking publicly traded companies, we're talking private companies. And so 26 million is a lot. It covers a lot of companies. And if it's 20, not that you're making 26 million from California, it's that you're making 26 million nationwide, or I guess worldwide, for a company that has a global activity. And it is 250,000 individuals. I mean, that covers a lot of, and if you get into sensitive data, which would be health data about sexual preference, or I think financial data, some of the sensitive data, 50,000, that's mom and pops are excluded. Absolutely. Right. All your small businesses don't have to worry, clearly.
Well, and even larger businesses, if you're manufacturing,
exactly,
those kinds of things.
Although, Wayne, consumer includes employee. So if you are a manufacturer, car company, you're selling not to consumers, but you're selling to dealers.
Right.
So you're B2B in essence. But if you have 250,000 employees, you're going to be covered.
Okay, that's
that employee data is covered.
That's a good catch.
That's a big company, but now we're talking.
So they seems like they tried to sweep in appropriately sized businesses.
Exactly.
Not protect every consumer in every situation.
Yeah.
But size this
Right.
appropriately for the burden it will take.
And secondly, there's another sizing or scaling element to this, which is the effective date. So they have a pretty generous, I think,
Mm.
implementation scheme here for companies over $100 million, the really big companies. They're the first ones that have to do the audit, and they don't have to file their audit until April 2028, covering 2027. And then it goes from there. The next tranche is people who file in 2029 based on 2028, and then those who file in 2030 based on 2029, and then it doesn't kick in for everybody else
Mm.
until basically 2031 for the 2030
Right.
year.
Gives time. Well, let me talk to you about the other piece here that I thought was interesting, but it doesn't seem to have been much of a disputed point. It's this idea of an internal versus external auditor. I mean, you never allow that in the accounting world.
Exactly.
So why here is it pretty, was it
I
well
think
accepted that you could do internal auditors?
that was a way from the beginning, and it always said internal or external. Even the original draft of the rule said internal or external. And I think that was a way of just easing the burden on companies, recognizing that you should have already somebody inside the company who is overseeing and assessing on a regular basis your cybersecurity activity, starting with that data inventory, your risk analysis, your development of your controls, and then your regular, at least annual review of are the employees following through on our cybersecurity policy, and is it effective? That company should already be doing that.
Mhm.
If they're not doing that and they have a breach and the regulators come knocking, that company's going to start out in a hole. The company that says, oh, we either don't have an inventory, or we don't have a plan, or we adopted a plan, but we never looked at whether it was being implemented, and we never went back to see if it was effective. That company's going to be in a regulatory enforcement hole. So I think most companies should already have been doing this. This puts the regulatory requirement on it, and it makes it now possible for the agency, if and when it starts doing cybersecurity enforcement actions, the first thing it's going to do is it's going to say, show us your inventory,
Right.
show us your plan, and show us your audit.
Right.
And that right there, I mean, right now, the Department of Health and Human Services, for example, has a major, they've been doing it now for 10 months or so, enforcement initiative specifically focused on cybersecurity risk analysis of regulated healthcare entities, and basically saying the first thing we're going to look for is, have you done your risk analysis? And I think the regulatory agency will do it. Now they have the backing of the rule. Yeah, so the HHS is doing this. Other regulators will do this. Certainly the California State Attorney's General Office, when they do their cybersecurity investigations, look at, is the company doing risk assessment, and are they going back periodically to ask, how are we doing? What I think is very interesting about this rule, Wayne, is not only did the regulatory agency, the California Privacy Protection Agency, say you must do the annual audit, but they said that audit must focus on specific cybersecurity practices and controls, which to me is what really makes this rule significant. So again, to back up, remember, in California since 2020, companies doing business in California and protecting personal information, companies have been required under state law since 2020 to protect that information with reasonable, and I use the quotes because that is the word in the statute, reasonable cybersecurity procedures and measures. And then, in fact, in the same referendum, which amended the Privacy Act and created the board and created this rulemaking, mandated this rulemaking, the definition of covered information was greatly expanded. So California companies have always been under a duty, or have long been under a duty. And I think the Attorney General would say they've always been under it, under the UDAP law, the Unfair and Deceptive Acts and Practices, or unfair competition law in California, to protect the information, the personal information they collect. So then what is reasonable? Now, it's interesting, when Kamala Harris was Attorney General, she actually made reference to an external standard, something issued by the Center for Internet Security, saying that compliance with the critical controls identified by this third-party group, that's the minimum of reasonableness in California. That was a statement by her. It wasn't really binding, although she had the power she and subsequent attorneys general had the power to implement that, or to at least apply that. But now we have on the rule book for California a definition, in my mind, of what is reasonable cyber security, because the rule that was adopted says that the cybersecurity audit must assess specific components of a cybersecurity plan. Authentication, starting with multi-factor authentication for employees, contractors, and vendors that access personal information. Strong password management, identity and account management, making sure, for example, that when an employee leaves, their credentials are deactivated. The principle of least privilege, that no employee should have access to any data beyond their duties. Inventory, as I said, secure configuration of hardware and software, security patch management, antivirus, network monitoring, cybersecurity training, etc. As I counted them, nearly 24 specific controls that the audit must assess. Now, the auditor can always say, well, given the size and complexity of the business and the nature of the information collected, this particular control did not apply. I deem it not necessary or appropriate for this business. But they have to go through every single one, and one way or the other say, if it is applicable, they were doing it. If it wasn't applicable, why not? And if they if it was applicable and they weren't doing it, there's a gap, and then they have to address that in subsequent reviews. Did they fill that gap? So that gives, finally, for people doing business in California, some metes and bounds of what is reasonable cybersecurity. And I actually think that could be helpful to regulated entities covered by this rule, because for the first time ever, instead of reading all the enforcement actions and all the settlement documents and all of the agreements that were reached on a case-by-case basis, now you're being told by the regulator, these are the priority items.
Well, and I got to tell you, I was pretty skeptical up front of any agency or any legislative body giving specific technical controls and guidelines, because when that's happened in the past, they usually outdated within the printing cycle of the next book. So I was actually pretty impressed by this list. They're not technical requirements, they're categories, and it's hard for me to ever see these categories all disappearing.
Exactly. I mean, identity, management, identity and access management, as long as you have people interacting with computers, or for that matter, computers interacting with computers, because it
Right.
covers accounts as well as individuals, you're going to need to control the creation, provisioning, and revocation of those identities and those access credentials. Exactly. And in fact, it's interesting, Wayne, you mentioned that, because there was one on the list that was eliminated in the process, and that was this concept of zero trust architecture.
Uh,
Zero trust architecture is the theory that you may already have bad guys you probably already have bad guys in your system. So what you want to do is, even within your firewall, even within your network, you want to require individuals and machines to regularly uh, authenticate themselves based upon their permission level, and basically don't trust anything, even if it looks like it's already inside your network. It's a little bit of a buzzword. It had grown in popularity. You see it in FTC orders, although I'm not sure it was in the more recent FTC orders. It had been a little buzzwordy and it dropped out. On the other hand, they kept encryption of personal information at rest and in transit. And again, I don't think the notion of encryption is ever going to be outdated. They don't say which algorithm you have to use. They don't really, go into, well, you must use this technology or that technology, but the concept of encryption, it's sort of like, I don't see that ever being outdated, something that, oh, don't have to worry about that anymore. Oh, that's outdated.
well, Jim, like I said, when I read through this, it all looks pretty straightforward. My litigator's mind turns to, wow, this is a creation of a lot of new documents, a lot of new evidence, a lot of new obligations. This becomes a plaintiff's lawyer's dream in many ways.
Yeah, that's true. Although, of course, those plaintiffs' lawyers already have a lot of information that they can get. Um, you know, Even after an incident on the forensic report, um, companies and their lawyers have tried to invoke attorney-client privilege, and they've been quite often unsuccessful.
Mm.
I mean, this is one of your areas of expertise, Wayne, so I don't need to tell you this, but obviously, if the report was prepared for business purposes, um, and not specifically in connection with litigation, then it may well be discoverable and not protected by attorney-client privilege. I don't see this being protected by attorney-client privilege, even if you tried to jury rig it by having the lawyers hire the auditor. I don't think that's going to work. It is in order to comply with a statutory regulatory requirement. So, yeah, but remember again, once the incident occurs, pretty much all the plaintiff's lawyers manage to get a full image of the victim company's system and network. They manage to get the forensic report. They're going to get all of those Slack channel conversations before the incident where the tech team is saying, oh, we got a real problem here, or we're vulnerable on this or that. Um, all that's all that's discoverable anyhow. This comes in a nice tidy package. It comes with a nice bow on it. Absolutely. It'll be on the list, but on that discovery list, this is going to be one item out of many.
Just one more. Well, then let me ask one other question. You have the option for outside auditors or inside auditors. Do you see or recommend a particular path for different types of companies?
No, I don't, because we know, even with the true auditors, that hiring your outside auditor, um, the true, financial auditor, FASB certified, FASB
Right.
compliant auditor, um, you still sometimes get poor audits that conform to what the management wants to hear. So I think if anything, yeah, there is already and will be a sort of talent deficit here. Yeah, are you going to have some pretty cookie cutter audits? Yes. I really think the question comes down to, will the CISO, the Chief Information Security Officer, or others at that senior level, including possibly the general counsel, will they insist that the audit be a real audit? And whether it's inside or outside at that point doesn't matter, because that outside auditor can just as easily get the signs and signals that this is not expected to be a serious audit. Whereas an inside person with sufficient overhead coverage within the company, an inside person can do a very serious audit if they have the air cover.
So what I take away from that is, as soon as you have a reported breach, these audits are going to be the roadmap to whether you did what you needed to or not, or whether you were hiding things or ignoring this for a long period of time, because you're going to have a trail of.
Yeah. But again, I mean, you're the litigator, I'm not. You would make just as much hay out of the non-existence of an audit, or you would make just as much hay out of a slipshod audit as you would out of a critical audit. Right?
Agree here. What we're looking at is, now you've got a rule that says you should be doing an audit, and if you do a poor audit,
no,
that looks a whole lot worse than.
No, 100%. I agree.
So.
I mean, right there again, you're in a hole trying to explain, whether it's to a regulator or to a judge or jury in the context of civil litigation. Right. If you haven't done a good solid audit, and for that matter, if it hasn't been presented to the board, even though this doesn't require it to go to the board, if it hasn't been treated seriously, if it just sort of is thrown over the fence and everybody ignores it, all of that can and will be used against you, undoubtedly.
So is this fair to say, companies that were really serious about this to begin with, last year before, they were already doing these kinds of high-end audits? They were doing it right.
Yes.
So it doesn't actually change that much for those that were already taking it seriously.
That's right. No, exactly. But I think there's a lot, I mean, we see in case after case,
right,
case after case, where they weren't taking it seriously. And that's a lot, you see it, because I just looked at them recently. I have a small piece that I'll probably publish with the IAPP next week on risk assessments. And risk assessment is basically a requirement under the HIPAA security rule for health information. And yet the HHS, Office for Civil Rights, which does the enforcement there, they find case after case where the company did no risk assessment or did a slipshod risk assessment. So I'm sure that this is going to get and should get the attention of a wide range of companies, large and small. I think there may be some large companies that aren't doing it right either.
Well, and that was one of the complaints I heard is, oh, this is one more example of a California regulation burdening businesses. But actually, this is just making sure those that weren't already doing the work are up to minimum standards. Not really new for the top big folks.
Not really new, and for the top big folks, and not really new for anybody who's been paying attention to the cybersecurity enforcement and litigation landscape. Because again, when the breach, Federal Trade Commission, California State AG's office, they look at a lot more cases than they actually prosecute. And what is the distinguishing factor between the cases that they bring enforcement actions against and the cases where they say, thanks very much, matter closed? And the difference is, what is the story that you tell? Because the bad guys are going to get through. the bad guys get through and bad stuff happens. And then the question is, what is the story you have to tell? And can you go in and say, we had a program, we had a senior responsible officer, we did the audits, we did the training, we did the inventory, we imposed all these protections, da 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 da, and we had third-party vendor oversight, etc. And yeah, the Chinese PLA or MSS, Ministry of State Security, they hammered away at us and they got in. Okay, we admit it. But if you've got that story to tell, the regulator's going to say, okay, we're not going to put you through the ringer.
Well, that's, from, again, I'm the litigator in the world. Reading this, that's what it came across to me as, is that it's nice. It defines what you should do. It helps a general counsel or maybe if you don't have a chief privacy officer yet, to invest resources in these types of activities to say, I need an external auditor. We need to do some things.
Exactly.
It really brings up the bottom of the pack to the middle.
It empowers the GC, it empowers the Chief Information Security Officer, and it empowers any board member who cares about these and wants to start asking those questions. And so it is a club. I think it's well crafted. I think they didn't go crazy on this list of components, even though there's nearly 24 of them. It's, as you say, it's hard to look at that list and say, oh, that's just icing on the cake. And that's the environment we live in today, Wayne, in terms of the cybersecurity threat that's out there, the vulnerabilities that we have, the APTs, the advanced persistent threats, both state-sponsored as well as criminal gangs. So I think it's good. I think it's an important addition to the picture. I think it, once again, puts California out there in the lead. Interesting question about whether other states will go down this road. As far as I know, no other state has quite the same provision in its privacy law. We now are up over 35 states that do have that reasonable cybersecurity requirement. In addition to California, New York is very, very active. The New York State Department of Financial Services, I would say, is the second most important cybersecurity regulatory agency at the state level. And the state AG for New York and the superintendent of the Department of Financial Services have been very active on cybersecurity. You've also, though, got Indiana, Connecticut, New Jersey. I think we'll see what comes out of Texas. So you've got some pretty activist state regulators.
So last question for you, Jim. So right now, the numbers, 50,000, 250,000, 26 million, are all pretty high. Do you see that eventually coming down to apply to small doctors' offices and just anybody?
I really don't. I really don't. I mean, the small doctors' offices, they are covered by HIPAA, which, by the way, can be enforced by the states. So the Health Insurance Portability and Accountability Act security rule applies quite far down the chain. Some of the financial services regulation applies quite far down the chain. And remember, of course, with credit card data and the merchants on the credit card data, the payment card industry, basically Visa and MasterCard, have issued their data security standard, which is imposed by contract through that chain. And there's a small business version of that, but in order to be accepted as a merchant accepting credit cards for payment, you do have to meet some minimum standards enforced there by contract. But on this one, so some of the small businesses are covered. It's not like small businesses are totally exempt from cybersecurity obligations under the sector by sector approach we have. I don't see these numbers coming down. Certainly my advice to the CPPA, if they were to ask me, would be, let's do an experiment and let's see how this works out. And by the way, one more thing, Wayne, these audits do not have to be submitted to the CPPA. You do them and you submit a certification certifying that you've done the audit, but you don't submit the audit. However, and that's in contrast to the risk assessment. So under this other rule that was adopted on risk assessments, the risk assessments do have to be submitted to the agency, but the CPPA has full authority in statute to demand pretty much anything they want from any covered entity. And they could do, and certainly if I were recommending, I would recommend that in a couple of years after 2030, they do a couple of sweeps where almost on a randomized basis, they can send out a request to 100 entities. Just pick and choose them from a hat, use an algorithm to choose them, and ask to see, and they would have the power to see the audit reports for businesses. And they've done these sweeps on other issues, and the Attorney General also has a similar sweep authority. So I think after 2030, after there's a little bit of experience under the belt with this, after some of the FUD has shaken out, I think we might well see that kind of scrutiny. And then that would inform, not until you've done something like that could you begin even talking about amending the rule or changing the thresholds.
Wonderful. Well, Jim, thank you. I've taken
Awesome.
up enough of your time today. This is a
Beautiful.
great introduction to a topic that's going to be very important to people sooner than they think.
Yeah, exactly. And by the way, you do need to get those processes in order. Exactly. And you need to start thinking about who's responsible for this, and are you going to do it in-house? Are you going to hire someone externally? So yeah, people need to start working. And do you have the processes inside to give the answers to these questions? And then
Right.
you want the answers to be check, yes, yes, yes. So you got to get the controls in place now.
You don't start studying for the test while taking the test.
Exactly.
So
Exactly.
that's a good idea. That's about a year or so in advance. You need to make sure you can answer these
Exactly.
questions. So
Okay,
well,
Wayne, awesome.
thank you.
Delighted. Anytime.